Article 1846, the surname of a limited partner shall not appear in the partnership name unless 1. It is also the surname of a general partner, or 2. Prior to the time when the limited partner became such, the business has been carried on under a name in which his surname appeared. A limited partner whose surname appears in a partnership name contrary to the provisions of the first paragraph is liable as a general partner to partnership creditors who extend credit to the partnership without actual knowledge that he is not a general partner. Effect where the surname of the limited partner appears in the partnership name. The limited partner violating this article is liable, as a general rule, to partnership creditors without, however, the rights of a general partner with respect to third persons with actual knowledge that he is only a limited partner. Contribution. Article 1845. The contributions of a limited partner may be cash or property, but not services. Limited partner's contribution. Medium. A limited partner is not allowed to contribute services. He can contribute only money or property, otherwise he shall be considered an industrial and general partner, in which case he shall not be exempted from personal liability. A partner may be general partner and a limited partner in the same partnership at the same time, provided that this fact shall be stated in the certificate provided for in Article 1844. A limited partner may not be an industrial partner in view of Article 1845, which requires that a limited partner must be a capital contributor. Time. The contribution of each limited partner must be paid before the formation of the limited partnership, although, with respect to the additional contributions, they may be paid after the limited partnership has been formed. Article 1857. A limited partner shall not receive from a general partner or out of partnership property any part of his contributions until 1. All liabilities of the partnership, except liabilities to general partners and to limited partners on account of their contributions, have been paid, or there remains property of the partnership sufficient to pay them, to the consent of all members is had, unless the return of the contribution may be rightfully demanded under the provisions of the second paragraph, and 3. The certificate is cancelled or so amended as to set forth the withdrawal or reduction, subject to the provisions of the first paragraph. A limited partner may rightfully demand the return of his contribution, 1. On the dissolution of a partnership, or 2. When the date specified in the certificate for its return has arrived, or 3. After he has 6 months' notice in writing to all other members, if no time is specified in the certificate, either for the return of the contribution or for the dissolution of the partnership. In the absence of any statement in the certificate to the contrary or the consent of all members, a limited partner, irrespective of the nature of his contribution, has only the right to demand and receive cash in return for his contribution. A limited partner may have the partnership dissolved and its affairs wound up when 1. He rightfully but unsuccessfully demands the return of his contribution, or 2. The other liabilities of the partnership have not been paid, or the partnership property is insufficient for their payment as required by the first paragraph. Number 1. And the limited partner would otherwise be entitled to the return of his contribution. Requisites for return of contribution of limited partner. All liabilities of the partnership have been paid, or if they have not been paid, the assets of the partnership are sufficient to pay the liabilities. The consent of all members general and limited has been obtained except when the return may be rightfully demanded, and the certificate is cancelled or so amended as to set forth the withdrawal or reduction of the contribution, when return a matter of right, on the dissolution of the partnership, or upon arrival of the date specified in the certificate of the return, or after the expiration of the 6 months. Notice in writing given by him to the other partners if no time is fixed in the certificate for the return of the contribution or for the dissolution of the partnership. Right of limited partner to cash in return for contribution. General rule, under the third paragraph. Even if a limited partner has contributed property, he has only the right to demand and receive cash for his contribution. Exceptions: when there is a stipulation to the contrary in the certificate, or where all the partners general and limited consent to the return other than in the form of cash. when limited partner may have partnership dissolved. The fourth paragraph provides for additional grounds for the dissolution of the partnership upon petition of a limited partner, when his demand for the return of his contribution is denied, although he has a right to such return, or when his contribution is not paid although he is entitled to its return because the other liabilities of the partnership have not been paid, or the partnership property insufficient for their payment. The limited partner must first ask the other partners to have the partnership dissolved. If they refuse, then he can seek the dissolution of the partnership by judicial decree. Liability Article 1848. A limited partner shall not become liable as a general partner unless, in addition to the exercise of his rights and powers as a limited partner, he takes part in the control of the business. Liability of limited partner for participating in management of partnership. Important. Take part in the management. Bare grant of apparent control to a limited partner is not sufficient to make limited partner liable as general partner. Control of business. Active participation in the management of the partnership business, not mere giving of advice. Business carried on by a board of directors chosen by the limited partner's appointee of limited partner becomes directing manager of the firm. Limited partner purchases entire property of the partnership and carries on the business in his own name. Party to a contract with creditors. Article 1858. A limited partner is liable to the partnership, 1 for the difference between his contribution as actually made and that stated in the certificate as having been made, and 2 for any unpaid contribution which he agreed in the certificate to make in the future at the time and on the conditions stated in the certificate. A limited partner holds as trustee for the partnership 1 specific property stated in the certificate as contributed by him, but which was not contributed or which has been wrongfully returned, and 2 money or other property wrongfully paid or conveyed to him on account of his contribution. The liabilities of a limited partner as set forth in this article can be waived or compromised only by the consent of all members. But a waiver or compromise shall not affect the right of a creditor of a partnership who extended credit or whose claim arose after the filing and before a cancellation or amendment of the certificate to enforce such liabilities. When a contributor has rightfully received the return in whole or in part of the capital of his contribution, he is nevertheless liable to the partnership for any sum not in excess of such return with interest necessary to discharge its liabilities. To all creditors who extended credit or whose claims arose before such return. Liabilities of a limited partner. To the partnership, liability of limited partners is to partnership, not the creditors of the partnership. To partnership creditors and other partners, a limited partner is liable for partnership obligations when contributes services, allows his surname to appear in the name of the firm, fails to have false statement in certificate corrected when he knew it to be false, takes part in control of business, receives partnership property as collateral security, payment, conveyance, or release in fraud of partnership creditors. Failure to substantially comply with legal requirements of formation of limited partnership. To separate creditors, creditor of limited partner may also apply for a charging order subjecting the interest in the partnership of the debtor partner for the payment of his obligation. Liability for unpaid contribution. Limited partner is liable not only for the difference between the amount of his actual contributions and that stated in the certificate as having been made, but also for any unpaid contribution he agreed to make at a future time. Liability as trustee, limited partner considered as trustee for the partnership for specific property stated in the certificate as contributed by him, but which he had not contributed. Specific property of the partnership which had been wrongfully returned to him, money wrongfully paid or conveyed to him on account of his contribution, and other property wrongfully paid or conveyed to him on account of his contribution. Requisites for waiver or compromise of liabilities. Waiver or compromise is made with the consent of all the partners, and the waiver or compromise does not prejudice partnership creditors who extend credit or whose claim arose before the cancellation or amendment of the certificate. Liability for return of contribution lawfully received. The limited partner is liable to the partnership for the return of contribution lawfully received by him to pay creditors who extended credit or whose claim arose before such return. His liability, of course, cannot exceed the sum received by him with interest.
Rights Article 1850, a general partner shall have all the rights and powers and be subject to all the restrictions and liabilities of a partner in a partnership without limited partners. However, without the written consent or ratification of this specific act by all the limited partners, a general partner or all of the general partners have no authority to 1. Do any act in contravention of the certificate, to do any act which would make it impossible to carry on the ordinary business of the partnership. 3. Confess a judgment against the partnership, for possess partnership property, or assign their rights in specific partnership property for other than a partnership purpose. 5. Admit a person as a general partner. 6. Admit a person as a limited partner, unless the right so to do is given. 7. Continue the business with partnership property on the death, retirement, insanity, civil interdiction, or insolvency of a general partner, unless the right so to do is given in the certificate. Rights, powers, and liabilities of a general partner. Right of control and limited personal liability. Entire control of business subject to all liabilities and restrictions. In the absence of an agreement to the contrary, he is not entitled to compensation for his services beyond his share of the profits, acts of administration, or acts of strict dominion. No power to do the specific acts under Article 1850 beyond the scope of the authority. If a general partner, other limitations, general partners have no power to bind limited partners beyond the latter's investment. No power to act beyond the purpose of the partnership. Article 1851. A limited partner shall have the same rights as a general partner to 1. Have the partnership books kept at the principal place of business of the partnership, and at a reasonable hour to inspect and copy any of them. To have on demand true and full information of all things affecting the partnership, and a formal account of partnership affairs, whenever circumstances render it just and reasonable. And 3. Have dissolution and winding up by decree of court. A limited partner shall have the right to receive a share of the profits or other compensation by way of income, and to the return of his contribution as provided in Articles 1856 and 1857. Rights of a limited partner improper on the part of general partners may not give a limited partner greater rights than the law what his contract grants him. Specific rights to require the partnership books be kept at the principal place of business, inspect and copy at a reasonable. Our partnership books demand a formal account. Ask for dissolution and winding up by decree of court, receive a share of the profits. Receive the return of his contribution, provided the partnership assets are in excess of all its liabilities. Article 1853. A person may be a general partner and a limited partner in the same partnership at the same time, provided that this fact shall be stated in the certificate provided for in Article 1844. A person who is a general and also at the same time a limited partner shall have all the rights and powers and be subject to all the restrictions of a general partner, except that, in respect to his contribution, he shall have the rights against the other members which he would have had if he were not also a general partner. One person as general and limited partner. Such fact must be stated in the certificate. Rights and powers are those of a general partner. With respect to his contribution as limited partner, he is a limited partner insofar as other partners are concerned, while he is not relieved from personal liability to third persons for partnership debts. He is entitled to recover from the general partners in the amount he has paid to such third persons in settling accounts after dissolution. He has priority over general partners in the return of their respective contributions.